regular meeting. And would you all stand and say the Pledge of Allegiance? I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, Kristen, do you want to do the roll call?
Yes, I will do roll call. Just say here if you're here. Rita.
Here.
Kristen, here. David.
Here.
Laura.
Here.
Chad.
Here.
Jeff.
Here.
Kevin.
Here.
We're all here.
Thank you. Okay, approval of the agenda. Does anybody have any changes or corrections they'd like to make to the agenda?
I don't think so.
All good? All right, then can I have a motion to approve the agenda?
So moved. Second.
Motion has been moved, seconded to approve the agenda. All in favor? Aye. Opposed? Okay. Now let's move on to the minutes from the March 15th meeting. Does anybody remember that meeting? Oh, by the way, welcome back, everybody.
I do have a couple of changes
Okay, Rita?
because I have my notes from that meeting.
And I don't know, not specific, even if everybody can make sure their mics are on when they're talking, because.
Thank you.
It was in item A, number 4. One of the items that because right now the original meeting said the critical dune restricts, and I had asked for it to be changed to the critical dunes area restricts placement, and that was not changed.
Okay.
Wait,
Yeah, you're, okay, the
Wait.
finding of fact number 4 under item C, then item, or
It
bullet
was
point C,
the-
then A, okay.
Right, it was item A for changes, number 4, where it says, remove the same size. There was an additional change that was requested in number 4 that was not made. Because the original March 15th minute says, the critical dune restricts placement of the same size garage on the north side of the house. I had requested critical dune gets replaced with the critical dunes area restricts.
So you're talking about the February 15th minutes, the corrections to the February 15th minutes.
Yes, so
And
the-
then you reviewed the final approved draft of those, and that's not accurate of what these minutes say?
no, we're reviewing the March 15th minutes, and the March 15th minutes, right? Right now, we're regarding the
That's
March
what I'm
15th.
trying to follow, I can't.
Okay, so there's been a continuing error, and I just don't, the March 15th, because it says approval of the February the 15th minutes, okay? So in the February 15th, when we reviewed them on March the 15th, I had requested a change in the March the 15th meetings to say critical dune area.
And that's not listed on these March 15th meeting minutes to correct the February 15th? meeting?
I don't know, I don't see any
It looks
March
like-
15th meeting minutes, I
I
see
think it's-
February the 15th.
These are the
No,
March,
this
these are
is
the
the
March
March.
15th.
Okay,
Packet.
Wait, go to.
so I'll start over. So the March 15th meeting minutes, right? So the March 15th meeting minutes were to review the February the 14th meeting minutes. So on the March 15th meeting, to review the February 14th minutes, I had requested in the March 15th minutes that the February 14th minutes get fixed. So if we're reviewing the March 15th minutes, it didn't correct what I had requested in the March 15th meeting.
Okay, so the 15th minutes don't accurately reflect all your corrections.
Correct. Yes.
Okay, sorry.
It's okay. No, I know, it's a lot of meeting minutes.
Is it here though? Because this was removed.
That was changed, but they forgot the first part.
Okay, that's what I wanted to clarify.
Okay, so what do we need to correct in the March 15th meeting?
So the March 15th meeting needs to say, change critical dunes to critical dunes areas.
Okay, so which one under the
It
change?
is finding of fact number 4.
Where it says remove of the same size?
Right, that was done,
But
Okay,
the second,
but in the beginning of the sentence, it was not fixed.
okay, so what needs to be fixed?
It needs to say critical dune areas, not critical dunes. It needs capital C, capital D, capital A.
Capital dune areas to replace,
Small, critical, small c, small d, and dunes.
replace critical dunes. Okay.
I have one other change.
Go ahead.
So as you go down item C, under finding of fact number 35, where it says last paragraph of finding of fact begins upon conclusion with no capital on the word to, as in to deny. That does not make any grammatical sense. So what I was suggesting that it says as in quote, ... to deny. Because if you read the sentence, it makes no sense.
So what should that line say in these minutes?
So the last, it's just a matter of making the big T a small t and to deny. That was the change that was supposed to happen. But the way she wrote the sentence doesn't make any sense. Because she wrote no capital on the word to, as in to deny. So to deny should be in quotes.
Okay.
That's it. That's all I got.
I had one correction. In addition, under A, meeting call to order at 6:00. Anything else? Okay, then I would like to make a motion that we approve the minutes from March 15th, from the March 15th meeting with with corrections.
So moved.
Is that a second?
Yes.
All in favor?
Aye.
Aye.
Opposed? Okay. Bob, do you have any comments you want to make? Moving on to public comments?
No.
Okay. Do we have any communications?
No.
Nope. There are no hearings, so I guess then we move on to item H, the zoning administrator's report.
It's on your desk. Do you have any questions?
You should be good. Okay. Okay. So if I have any questions for Sarah on this? No. And so.
Well, I can use that one. I'll grab that one.
Okay, then let's move on to the PC representatives report.
We're currently going over zoning ordinances and changes, different subjects. Sarah wants to elaborate on it a little bit, she can. Other than that, it's just a study session.
Yeah, so the planning commission is reviewing the draft zoning ordinance. It was a complete rewrite of the zoning ordinance. There was a steering committee that went through it, and so now the planning commission is working on it. I would encourage the zoning board of appeals to read through the zoning ZBA chapter and see if there's anything that you see or have issues with. My only kind of caveat on that is that the criteria that's listed in the draft is not updated to reflect the criteria that's currently going through the chain to get adopted to amend the current ordinance. So if you recall back quite a few months ago, and I know Laura, you were pretty involved in it, we were updating the criteria for the ZBA for the variance to try to make it clearer, easier to read, and then so when you're voting yes or no, you're actually affirming or denying the statement instead of trying to figure out does yes mean no, or so cleaning some of that up. So the draft, which is on the website, does not have that language in it yet because just of timing, because that draft.
Okay, but did they, that was already put through that change, right?
Yeah, it's at the county right now.
Okay,
So then the board, and so then once the board adopts it, I'll put it into the complete draft rewrite to be the new
Okay.
language.
And
So
when-
if you're
when
reading
is-
through it right now, you're gonna say, why isn't this updated? And that's why.
okay, and has the planning commission already looked at the ZBA section, or is that on your schedule at this point?
No, we've gotten in.
I don't remember the chapters that we reviewed and not reviewed, honestly.
Well, we went through 6, we went through 4,
Right, the last meeting we did like
and
3
2,
and 6.
2, 4, and 6, I believe.
We didn't get through 6 last time. Anyways,
I'm sorry, you've done chapters 2, 4,
I don't know. I'd have to go back and look. I can give you that information, but I
Okay.
don't recall which chapters we reviewed and which ones we haven't.
okay. I was just looking for a timeline, so everybody could take a look and know.
I would
when-
say that if you want to make comments before it goes through any kind of a public hearing, you'd want to do it by the end of September.
Okay.
That's not, a drop dead date, but if you'd like to had your comments integrated early on.
And is that rough draft or document that you're working with, is that on the Torch Lake Township website?
It should be because it's been a part of our packets, but I don't know. Let me double check, because it has been in the planning commission packet. So when the planning commission packet is up there, it's always been on there. But I don't know if they've cleared anything from our last meeting.
Okay, and if they haven't addressed that section yet, then it might not be.
It's the
on
whole
there.
ordinance. And so right now under the planning commission, it's got the whole ordinances on there. So we've just been using the same document that's dated from October of 2022.
Okay, so it's being put on there every time they're addressing that.
Right, and it's the
Document?
same document each time,
Okay.
and then we'll go through and review an updated document once we get through it.
Okay, thank you.
Yeah.
Okay, anybody else have questions regarding that? Then, Todd, your turn.
All right, well, good evening, everybody. I was asked to attend this meeting and talk with the ZBA about some training that Sarah was proposing, and I had gone back and done some review of some training sessions I've done for other ZBAs. As you can imagine, different townships are different in terms of their sophistication and their understanding of laws. I've got some townships that if they have a ZBA meeting 2 times a year, that's busy for them. Other ZBAs like this one pretty much meet on a regular monthly basis, and they have issues before it. And so There's a big difference from township to township in terms of the sophistication and how busy ZBAs are. But I think it's always important to take some time to either learn or maybe refresh your memory on some aspects of what it is to be a member of the ZBA and the process that needs to be followed, the rules and the laws that govern the ZBA process. And so that's kind of what Sarah and I decided to focus on a little bit tonight. The first item on the list of things to discuss is what is the ZBA? Well, obviously you guys are the ZBA, but zoning in the state of Michigan, as you likely know, is controlled by what we call as the Zoning Enabling Act. And prior to 2006, there were actually 3 different zoning enabling acts. There was one for townships, there was one for cities and villages, and there was one for counties. And in 2006, the state legislature looked at that and probably said that doesn't make any sense. And so they've combined all of the zoning enabling acts into one, which is the current Michigan Zoning Enabling Act. And there is a specific section of the Zoning Enabling Act that pertains to ZBAs and gives municipalities specific authorization to create ZBAs. Courts have characterized ZBAs as a quasi-judicial body, which means the ZBA decides questions that are put to it, and its decisions are binding on the township and the people in the township until a higher court says otherwise. And that's why you'll see in a lot of cases that come out talking about the concept of being somewhat of a judicial entity. You guys take the facts, which are determined by your findings of facts. You apply the law, which is usually the zoning ordinance that you're applying, and you reach a judicial decision. And it has the meaning of law. For example, if you were to interpret an ordinance in a particular way, that ordinance interpretation carries the weight of law and must be followed by the township until it's either changed in a zoning ordinance amendment or a court comes along and changes that. One of the things that I saw Bob hand out before the meeting started, or as the meeting was getting started, were the minutes and information from a request for an interpretation from Bob Spencer, which is one of those circumstances where the ZBA was asked to determine what do certain things within the ordinance mean. And so the ZBA considered that and said, this is what these terms mean. And that's binding on future zoning administrators and also ZBA decisions. And so that's kind of why the ZBA is characterized as a judicial entity and what that means. It's important, I think, for ZBA members to understand where your authority comes from. I've referenced the Zoning Enabling Act, and I do have a copy of the ZBA section of that statute. It's a rather large statute if you were to sit down and look at the entire thing, because it covers a lot of different topics. But the section solely on zoning boards of appeals is not that long. And what you'll see if you read through this is that it should be consistent with what your ordinance provisions are with respect to various matters, because it's the Zoning Enabling Act that is the authority for the township to create the ZBA and empower the ZBA. So townships, unlike states, are municipalities that have no inherent authority. The only authority that a township has is the authority that the state gives it. And so we look to the state statutes to tell us, okay, what can a township do and what can't it do? And the Zoning Enabling Act section relating to zoning boards of appeals is part of the authorization from the state saying you townships can do this. And so, you might want to get your hands on a copy of that and read it. I brought a copy and we can make copies for anybody who wants one. But we'll come back to that in a little bit because there are some sections of the Zoning Enabling Act, particularly as it relates to agreed party status and standards for granting variances that we're going to want to touch on a little bit later. So we start with the Zoning Enabling Act as really the statutory power that is granted to townships to create a ZBA. One of the things that the Zoning Enabling Act says is that the Zoning Board of Appeals is to create a set of rules that is going to govern that entity. And that's where your bylaws, or rules of procedure, different townships call them different things, come into play. That's another set of rules that governs the activities of the ZBA. While they're your rules and you're entitled to change them as you see fit, you should abide by them. And so if there are provisions that are applicable to a certain circumstance in your rules of procedure or your bylaws, then you want to make sure that you're following those, because in our society right now, the focus tends to be on gotcha moments. And you don't want to inadvertently give somebody an opportunity to say gotcha because you're not following your own internal rules and procedures. So bylaws are another thing. If you've not obtained a copy of those or received those, make sure that you do. By the way, I meant to say before I got started here, I intend this to be kind of a give and take session. If people have questions, please feel free to interrupt me. And I've told Sarah to feel free to jump in whenever she would like to add something to what I have been saying. So we've got the Zoning Enabling Act, we've got your bylaws. The other very important and probably most important set of rules that the Zoning Board of Appeals must follow is your own zoning ordinance. And your zoning ordinance currently contains a chapter 20, which is titled Zoning Board of Appeals. And if you've not reviewed that in the past, I would encourage you to do that soon, because these, again, are the rules that you are obligated to follow as it relates to your processing of the various types of matters that can come before the Zoning Board of Appeals. There are two other statutes that I always mention whenever I talk about training with the ZBA. And they don't specifically apply to the ZBA, but they apply to the township as a whole. And those are the Open Meetings Act and the Freedom of Information Act. And the Open Meetings Act requires that any legislative activity, judicial activity by the ZBA, basically anything where decisions are being made that is going to be put into practice, that has to be done in the public's eye. 10, 15 years ago, these were labeled sunshine laws because they allowed the public to see what was going on in their municipality. And the Open Meetings Act is one of them. And where I see it come into play more often in the ZBA is in a couple places. If you do site inspections, for example, you want to make sure that you have less than a quorum of any of you visiting the site at any one given time. Because the Open Meetings Act says if you've got a quorum, you've got a meeting. And if you're working towards a decision on something, you've got to notice that out. You've got to invite the public to attend, so on and so forth. So, go ahead.
I think I have a question related to that. So I noticed in the Zoning Enabling Act that it says the Zoning Board of Appeals shall not conduct business unless a majority of the regular members of the Zoning Board of Appeals are present. And at that time, it struck me because I think we were talking about having a hearing with like 2 regular members and 2 alternates. And so if I understand this correctly, we can't do that. We have to have 3 regular members here to conduct business. So then, do you have to have 3 regular members together? I mean, would it be in violation to have 3 regular members? Could you have 2 regular members and 1 alternate at a site visit and it still not be considered a meeting?
I would not want to
I-
stand up in front of a court and argue that an alternate is not a regular member of the ZBA. I would, particularly if that alternate's going to participate in the discussion. So what I often advise people to do is go out there on your own, take your notes, write down your questions, whatever information you gather from that site visit, and don't really discuss it with anybody else until you get back to the meeting at which you're considering the issue that pertains to that property.
And I thought that's what we had decided as a group, that we would do our site visits
Yeah,
individually.
We had, I just, that sort of, dovetailed into that question that I had of the actual meetings and hearing,
like what
hearing cases,
constitutes.
conducting business. So am I correct in understanding that we could not hear a case with 2 regular members and 2 alternates? We'd have to have at least 3 regular members?
Bob says I'm not close enough to the mic.
Let me give you a difference.
There is a difference
share.
in which provision of the zoning enabling?
Okay, this is
Real quick.
Article 4, the first section 125.3601, and then scroll down to item 12 under that. So it's really on the second page of the part that addresses zoning board.
Yeah, so what this is saying is that you cannot conduct business unless you have a quorum of regular ZBA members.
So that is in fact true. It'd have to be at least 3 of the regular members.
And you got a 5-member board?
We've got a
yeah.
5-member board, so we could not conduct business with 2 regular members and 2 alternates.
Correct.
Laura, could you talk, where are you reading that from?
This is,
Is that
it's the Michigan Zoning Enabling Act.
okay, that's what I wanted to verify.
And-
Okay,
I just downloaded it from the internet and printed it out and read through
Okay.
it. I don't know, because I had questions at some point in time and
good idea.
then I read it again after we had talked. The meeting was canceled, but we were looking at trying to,
Hold it. See if we could hold
yeah,
it.
have enough people. And I think we were looking at 2 alternates and 2 regular members, not 3 regular members. And I think the applicant decided to wait till we had a full board or something.
Yes,
I don't
think you're
remember
right.
exactly, but I know that issue was kind of on my mind because I didn't realize that until I read this.
So now we know.
Can we pause for just a moment to rearrange the tables?
Sure. What am I doing?
We're gonna back up something over this way a little bit more. So we're not on the speaker. I think that's the issue. With the microphones. I usually sit over here.
Was yours getting feedback too?
No, we didn't even talk.
How is that? Is that any better? Oh, I couldn't hear it anyway.
I hear a little feedback.
You want to sit over here, Todd? I'll change places with you.
While we're being on. Okay, I'm gonna talk on our question. Todd, you had mentioned, and I know as a board on a site visit, of, no quorums, which of a 5-person board, that's 3, correct?
Correct.
So I guess, having done this for a long time, not as a ZBA member, but there's a lot of informational types of things that we go to, whether we're 5 members or 3 or 2 is a quorum, but it's for information, which is allowed for informational purposes. Am I correct with that?
If you're not going for the purpose of conducting business,
Right.
like deliberating towards a decision, then yes, you can. I mean, you can all show up at the same,
Right,
informational night at the Township Hall.
right.
You can all run into each other accidentally at the grocery store or at a restaurant, those kinds of things. The issue is, are you conducting business of the township and working towards a decision is the
Okay.
issue.
Okay, so the second part of my question is on a site visit, as we go out and we see this one-on-one and we go through this, and Dave shows up and I'm on the job site. We didn't talk about it. It's just your chance to go out there and we look and I go, well, Exhibit A says this and we're doing this. There's no business being done other than we happen to be on the site at the same time. And I guess my position would be, there's no quorum. I'm not here to conduct business other than for a site visit for future reference. And I guess I just have a real issue with the fact that if there's 2 people on a job site or what's in question, and having the fear put into people that you can't be there. You follow me? You know what I'm saying? I guess I want to be able to go to a job or a site visit. And if we have another person there, as long as, to me, if I don't have a quorum there, I'm not conducting business, nor could I conduct business because I don't have enough members to conduct business.
I don't disagree with that. What I advise people of is be mindful of the optics of it.
Right.
And do you want to invite the critique and the argument that you did something wrong?
I
And
understand.
actually, it's a really good point you bring that up, because we had decided, I think, before you joined our board, that we would just, if you pull up and someone else is on the site, just wait in your car or wait, give them the time, because it's not like we're there for an exorbitant, we hopefully aren't there for, give them the time, and then when they leave, then you can step on the property, because we wanted to be very transparent
Right,
and not look like we're,
right. No, I understand.
So I was always fond of telling my son, just because you can do it doesn't mean it's a good idea.
Right. No, I understand what you're saying.
So,
Thank you.
Technically, you're correct. You're not in violation of an Open Meetings Act,
Right.
but do you want to have to spend the time defending what probably shouldn't need to be defended in the first place?
As we all know, we can do the best we can do, and you still run the risk,
Oh, yeah.
right? So I guess personally, I'm not living in fear with that.
Good points. All good points. The other area where I see people getting tripped up in Open Meetings Act violations are on email communications. And courts have ruled that taking votes via email before a meeting, the straw votes, so to speak, carrying on discussions via email where everybody's in the same email chain, or it's even a little more insidious than that, where it gets sent from one person to another, but everybody gets to see the email chain and weigh in on the discussion. Those can be deemed activities of the ZBA that violate the Open Meetings Act. So I always caution any municipal board member, whether it's ZBA or planning commission or township board, to be very careful about your email communications. And that dovetails into the next statute, which is the Freedom of Information Act, which emails can be subject to FOIA, even emails on your personal devices, your iPhone or your Samsung device or your computer at home. And so through the Freedom of Information Act, that's opened up the door for people to be able to request copies of emails that are shared. And so that chain, that communication going on, which may come close to the line of violating the Open Meetings Act, is oftentimes there for people to see and to find. And so, again, mundane email communications, here's the proposed agenda for Tuesday night. Come prepared to talk about if you want to add anything to it, or reminders about the meetings upcoming. Here's the board packet. Just mundane type emails are best and save the serious discussion and going back and forth for the meeting.
And that's why I blind copy the ZBA when I send an email out. So when you accidentally hit reply all, it only comes back to me. It doesn't go back to everybody else. I don't know if you've ever noticed that, but you're probably like, did everybody get this or not? But that's why I usually say, hi, ZBA members. So hopefully you can know that I send it to everybody, and I do that very intentionally when I'm trying to communicate with the ZBA or any of the boards, just so that if you do happen to hit reply all, it doesn't go back to everybody and it doesn't start anything. It may be as simple as a yes or no, and it could go nowhere, but that just kind of helps so that it doesn't get off task and people start trying to pick a meeting date and then something else happens. So I'm very intentional when I do it for the blind copy, for the reply all.
So another thing that a lot of people have questions about as it relates to the Freedom of Information Act is, are my personal notes that I take at a board meeting or my notes going out to a site visit, are those subject to the Freedom of Information Act, and do I have to keep those and produce those? Generally, the answer is no, you don't. The only time that note or your notes might be subject to FOIA is if they form a basis for an official action. For example, if you go to a site visit and you draw a sketch that the ZBA adopts for some reason and includes it in the minutes, well, then that sketch of yours would likely be subject to FOIA. But if you're keeping notes of public comment, or you're keeping notes of the presenter's comments and then Sarah's comments as you go through the meeting, those generally are not going to be subject to FOIA. And I didn't check with the township's document retention program, but I doubt that it would pertain to your personal notes anyway. But you should probably just keep those until the minutes of that meeting get approved, and then you're free to keep them, destroy them, whatever you want to do. Always make sure you conduct business on the township's email system. I think all of you have township email addresses. If you inadvertently use your personal email, that may open up you to having to produce your computer or give a release to obtain your personal emails if it were to go to a lawsuit on, say, a Freedom of Information Act claim. And so just don't even run that risk. Always make sure you're utilizing your official township email when communicating in that way. Any questions about the statutes or anything? Like I said, I've got copies of all of these statutes up here if you would like a copy. I don't have copies. I have a copy, and we can make more if you would like to have them. The next topic is processing an appeal or a variance. And probably what you have found in the course of your work is that what you're asked to do more often than anything is either handle the appeal of a decision made by the zoning administrator, either in the issuance of a land use permit or the failure to issue a land use permit, or the request for a dimensional variance. Those are probably your two most often dealt with scenarios. There are a couple other things that could come up. I mentioned the Bob Spencer interpretation request. The ZBA is also empowered to interpret various provisions of the ordinance. And sometimes in the decision of an appeal of a zoning administrator's determination, you find yourself having to interpret the ordinance in that context as well. The helicopter pad case that we had several months ago, I think comes to mind. I think that involved several different aspects, but it certainly included some interpretation of some ordinance provisions in order to reach a decision in that matter. And so the Zoning Enabling Act and your bylaws, as well as your zoning ordinance, have some provisions that pertain to these types of activities. And one of the things that I want to talk about is who has the authority to ask for what from the ZBA. Because depending on what it is they're asking for, different people might have the ability to ask for it while others are precluded. For example, an appeal, according to the Zoning Enabling Act, can only be filed by an aggrieved party. And contrast that with a request for an interpretation is usually permitted by anybody within the township. And so when you get a request for an activity, you need to ask yourself, is this person authorized under our zoning ordinance to ask for what it is they're asking for? And so I took the opportunity to look at your zoning ordinance on your website, and there's a provision in here that hopefully you're changing. If you're not, I think we should. So Article 20, section, get to the right area, 20.09 procedures. Subsection A says an appeal or review of any ruling of the zoning administrator or other administrative office administering any portion of this ordinance may be taken by any person, comma, any aggrieved person, or any governmental department affected or aggrieved. I would suggest you take out the language may be taken by any person. Because the way your ordinance is written right now, anybody can appeal or ask for the review of any ruling of the zoning administrator or any other administrator.
Could you repeat that, Todd, the reasoning for that?
The Zoning Enabling Act says that an appeal to the Zoning Board of Appeals may be taken by a person aggrieved. So the Zoning Enabling Act limits appeals to the ZBA to persons that are aggrieved. There's a couple other categories, but they really aren't applicable. Your zoning ordinance, as I read it, is broader than that and says any person can ask for an appeal. The Michigan Supreme Court recently addressed the issue of who is an aggrieved party in a case that it published in July of last year, July 2022. This is the Saugatuck Dunes Coastal Alliance versus Saugatuck Township case. And they revised the definition of who an aggrieved party is, and that is, and this aggrieved party status is important both in front of the ZBA as well as in front of the circuit court, which we're going to talk about in a little bit. But it says an aggrieved party must meet 3 criteria. First, the appellant must have participated in the challenged proceedings by taking a position on the contested proposal or decision. Second, the appellant must claim some protected interest or protected personal, pecuniary, or property right that will be or is likely to be affected by the challenged decision. And third, the appellant must provide some evidence of special damages arising from the challenged decision in the form of an actual or likely injury to or burden on the asserted interest or rights. Anyway, they got to show special damages is what the Supreme Court is saying.
I'm sorry, what decision, can we get copies of that? Or is that a certain decision that I couldn't take my notes fast enough.
We can make copies of this
Okay.
opinion right here for you.
Okay.
And why that is important is because not everyone should be allowed to tie up the ZBA with requests for appeals of decisions that most likely Sarah makes. For example, somebody who gets a land use permit on the south side of the township shouldn't really be able to be challenged by somebody that lives clear up on the north side of the township just because they don't happen to like the ruling or the decision that is made by the zoning administrator. And so that's why courts have written into, and the Zoning Enabling Act talks about it, your ordinance talks about it, but I think you skirt that issue, is this concept of an aggrieved party status coming before you. And the purpose is twofold. One, to make sure that they will purposely and forcefully pursue the issue. And secondly, that they really have a dog in the hunt to justify allowing them coming before the board. And so more often than not, appeals of zoning administrator decisions are the person who didn't get the permit that they wanted or didn't get this or that they asked for. That person clearly has standing. But when it's neighbors 5 miles down the road who are trying to appeal something, then you got to start asking yourself, does this person have the right to come before this board and ask us to make this decision? And that's the analysis that you walk through, those 3 elements, which is, are they going to be harmed in some way by the decision? And do they have special damages that are different than other people in the community? So I would recommend you consider changing that if it's not already.
The draft mimics state law.
Okay. So that'll get fixed.
Yes.
Okay.
And a lot of this too, the ZBA, I mean, if somebody files an application for an interpretation, well, maybe not an interpretation, but a appeal of my decision, and it's not the property owner, I'm gonna call Todd and say, Todd, can this person do this? Before it even gets to the ZBA. Hopefully that's not a question you're having to ask through this process. Should this person even be here? Because that's already been discussed before you see it.
So the other section of the zoning ordinance that is applicable as it relates to who can do what is subsection B of 20.9, which says an application for variance interpretation. Although I'm not sure I understand what variance interpretation is. I interpret that to mean An application for an interpretation may be taken by any person or governmental department that is affected. So that's kind of how Bob Spencer got the right to ask the ZBA to interpret the sections of the ordinance relating to, I think, construction and some other questions that he had regarding riprap and other issues along lake shores. So a request for an interpretation is generally broader in terms of the scope of the people that can ask the ZBA to take action on it. Variances and appeals are more narrow in terms of the people that are entitled to ask for that relief. And like I said, we've got a copy of the Supreme Court opinion that you can take a look at and wade through and see how that all comes together. One of the things that Sarah put in the agenda here is flow of the meeting, and quite frankly, I'm not exactly sure what that refers to.
I think it was just, I didn't want to have to put, you have an agenda, you open a public hearing. I think that, Laura, you've got that process down. We usually put that right on the agenda, that part of the meeting. So I didn't think you needed to spend too much time going over how to go through a public hearing.
Oftentimes, your rules of procedure will,
That's what I base that section on, is what our rules and procedures say.
and 9 times out of 10, that's going to work just fine. The 1 time or the 10% of the cases, there may be a reason to deviate from that. We had a rather lengthy appeal process up in Hayes Township about 6 months ago that took us 3 meetings to get through. And it really made sense to have the applicant go first instead of the zoning administrator because the applicant had all of the information that the ZBA needed to consider. And so if we followed the policy and procedures of the Hayes Township ZBA, they'd hear from the zoning administrator first and then the applicant. But that was going to force us to go back to the zoning administrator again to respond to the applicant's response or presentation. And so we just amended the procedure for that meeting to flip-flop those two. So the applicant went first and then the zoning administrator went second.
So would you do that during the meeting when you're approving the agenda, or is it?
That's the way we did
Point it
it.
out and
Right.
the agreement that that's how it's going to be
Correct.
handled? Okay.
It's your meeting. You have the ability to run it in the way that you want. You should give honor and respect to the bylaws and the rules of procedure, but those are guidelines. Those aren't hard and fast rules. You have the ability to change them if the circumstances dictate.
And we might have put that in, maybe it was the PC, I was gonna look them up. Because one of the bylaws we actually put in at the discretion of the chair or the chair, because we kind of felt that it was kind of rigid sometimes and the agenda could be rearranged and that would be at the call of the chair, would be able to do that. I don't know if we did that for the ZBA, but
I
we,
don't recall unless the PC did it when reviewing that section, but I don't recall doing that.
yeah, okay, it might have been a different board.
So, that really pertains to agenda items and just sticking to your agenda. The next issue is memorializing decisions. And I think from the ZBA perspective, this is probably the most important thing that you do. Because as a quasi judicial body, your decisions can be appealed to usually the circuit court is where the appeals go. And so what I always tell ZBAs is the most important thing is that the court can look at the minutes of a meeting that you conduct and understand what you did and why you did it. It's that simple, because an appeal by definition is a review of what was done at a lower level. And if the court above cannot figure out what you did, or maybe why you did it, then one of the options that the circuit court has is to send it back to the ZBA for further proceedings to fill in the missing information. And so that's why it's important, and I know that this group spends an awful lot of time on minutes and making sure that the minutes are accurate. And I went back and I looked at the minutes for approximately the last year of the ZBA, and I think by and large, they were very good. The minutes are kind of a hard, I think anyway, middle ground to reach, because it's not intended to be a transcript of what occurs at a meeting, but yet it's got to be specific enough, again, to be able to tell what you did and why you did it. And so you're kind of searching for that middle ground of a summary of what is going on at the meeting. Now, when we get into specific findings of fact and those types of things, when you're working towards a decision on a variance request, that does need to be very specific, and you guys are very good about doing that. But the rest of the meeting, can be a little more summary style than verbatim style. One of the meetings that I looked at was your November 16, 2022 meeting, and that was the helicopter landing pad case. And that was a rather long meeting, and the minutes reflect that. But certain areas of the minutes contain a lot more detail in them than they necessarily need to. For example, presentation of the staff, communication that was received, even the presentation of the applicant can probably be shortened up a little bit and a little bit more summary than what is put in these minutes. And so, that's a tough, happy medium to find, so long as, like I said, the court can look at what was said and what was done and why you did it. That's what you're after. Another set of minutes that I wanted to talk about, and you received a copy of the court's decision on this case, was the Ansell case, which was the guy, I think you were amending the minutes of that or discussing that case earlier tonight with the critical dunes circumstance and whether or not he should be allowed to get a dimensional variance to build a garage that he wants to build. And what's good about that case is we have your minutes, which are very detailed. And I really, I like the findings of fact that you go through. I like how detailed they are. You've got 34 specific findings of fact in that set of minutes. If you were to ask me to critique that set of minutes, the one thing that I might ask you to do is after you've created your specific findings of fact, I've got no problem with setting them out the way that they are. Here are all the facts that we think are pertinent and important to this matter. You then move on to the specific standards that must be met in order to grant a variance. And what you do is you discuss that standard and then you vote on that standard. I might consider asking you to start having included in your minutes under that specific standard which specific findings of fact you believe support that conclusion that the ZBA reached. So in other words, you've got standard A, and I'm just going off these Ansell minutes. The criteria was met 4-1. And the ZBA determined that findings of fact numbers 2, 7, 15, 24, and 32 all supported this conclusion. That way, when the judge is faced with a long list of standard or findings of fact, and the judge is starting to focus in on specific considerations and conditions that must be met, the judge knows which findings you're relying on. rather than having to kind of have to ferret out from this long laundry list of findings of fact. And so that might be one thing that I would recommend that you do to make it a little easier for the court to determine exactly what you did and why you did it. Would be to include that.
And that kind of was a unique circumstance because typically the ZBA went through each of the standard and made a finding. But that one, the ZBA threw all the findings out at the beginning.
Everybody started talking about
Yeah.
different ones instead of just the relevant ones to the one we were
One
talking.
finding.
So I just kind of went with the flow and said, okay,
Yeah.
we're just going to go through the whole thing. In any case, would that be acceptable to just take each standard by itself and do the relevant finding of facts? for that?
Absolutely.
Okay.
Yeah.
Because I think that kind of might help bring our thought process together a little better too.
And Sarah and I talked about maybe some, how do I want to say this? I understand that all of you receive a form before the ZBA meeting, giving you an opportunity to look at each of the standards and maybe start drafting your own suggested findings of fact. And it might make some sense if those could be gathered a day or two before the meeting to create kind of a master list so that you're working from one sheet of paper, probably be more than one.
Okay, so I was under the assumption that that would be kind of like, that wouldn't be discussing it ahead of time or doing work.
You wouldn't be doing it. Sarah would be.
You would send them all into me, and then at the meeting, I would distribute the list with everybody's on one piece of paper.
And really, all she's doing is cutting and pasting. She's not making any decisions on, there may be 3 duplicate ones, but they're all going to be in there.
And hopefully I would put them all next to each other so you can go through and cross them out.
That would definitely
That would be
make
very,
it cohesive and speed
very
through.
helpful.
Right.
Yeah.
I think it'd be a lot easier for you to move through the findings of fact quicker because everything's right there in front of you. You're
I
not
agree.
looking at 4 or 5 different sheets of paper or trying to figure out, is this one similar to mine or not? So I think that might help.
So then the question would be, we would have to come up with something so we know how soon it needs to get to you and.
Right, and we'll probably work through that, but if you want to try it for the next case that we have, maybe, because I've kind of said I'm going to try to get the packets out earlier than when I have been, so you have more time, so hopefully that'll allow you the time to turn in the findings so that we can put them together. And not to say you can't come to the meeting with findings, you still could come to the meeting, but get most of the findings and everything put together in one document, and then hopefully we could go through, you can scratch off the ones you don't like, or go, hey, why don't we add this word in here? And everybody can just add that word. And they're kind of in order, because I know we spend a lot of time going, which one, whose is that? And
Yeah, I think that makes sense, especially if you get us the packets sooner, so then we have that turnaround time. Yeah.
So we'll try it, see what happens.
Why not?
So I want to move on to the discussion of appeals to the circuit court because you'll see it's a continuation of.
Can I
the
ask you a question
minutes.
about the
Sure.
findings of fact? So in an interpretation, are findings of fact required?
They may be if there are other sources of maybe a definition. You may find that Merriam-Webster's dictionary says this about this particular definition or whatnot, but they don't have to contain findings of fact per se.
Okay, so like on the July 8th one, there was no findings of facts in that. So that's okay that there's no findings of facts listed?
That's the Bob Spencer one.
The which one?
The Bob Spencer.
Oh.
So that was my question. So if somebody does an interpretation and someone comes before the ZBA with a case and they ask for an interpretation, is not the person who's asking for that interpretation supposed to receive findings of fact rather than just the ZBA saying, this is our decision, as opposed to basing it on something? So that was one of my questions tonight was, do you have to have findings of fact when someone comes before the ZBA for an interpretation?
You have to have a justification for the decision that you make. It can take probably several different forms, one of which would be a heading titled findings of fact, and you would regurgitate the bases for the decision that you make there. Other times it's just baked into the minutes of this is what the ZBA relied upon. Do you have to have, if what you're asking me is, do you have to have a specific heading that says these are the findings of fact? No, you don't, but that makes it easier for the reviewing court to figure out what it is you're relying on.
Okay, so just to make sure that I understand. So a ZBA can just say, this is my definition, and we're voting on it, but there's no basis, right? That justification to say, this is what a structure is. There's, because as I go back and look, I see nothing in that case that says there's any justification for their decision. That's why, that was one of my questions, is there an interpretation? Do you have to have a findings of fact, or what does this case or any interpretations have to have for it, for them to go ahead and vote?
Talking about this in a vacuum is difficult because every matter that comes before the ZBA is different.
Yeah.
I always come back to the judge has to understand what you did and why you did it. If the ZBA were asked to interpret a term in a zoning ordinance and just simply said, this is what we think it is or should be, then that's probably going to be subject to some judicial scrutiny as to whether or not it was an appropriate procedure for interpretation.
Okay.
On the other hand, if they say, we interpret this provision in this manner, and we do that because this term is defined as such in a dictionary of general circulation. We've looked at 5 other zoning ordinances that have contained the same provision, and they've interpreted it this way. Whatever the basis is for that decision, so long as that's articulated in the decision of the minutes of the meeting, then that would be appropriate. So it's difficult to sit here and tell you specifically that you've got to have so many findings of fact for each particular issue, because each particular issue is different.
Okay, we'll come back to that case later on.
So I have a question regarding, to follow up with Rita's question. I mean, there's times that we hear things or I've heard, findings of fact, but they're going to ask me, I'm going to give you a chapter in the zoning ordinance book, and that's my findings of fact. Like 7.07 or something. And that section right there is what I'm using without drilling down so far on it, on each item.
That's not so much a finding of fact as it is a conclusion of law. Because if you're referring to a specific section of the zoning ordinance, you're applying the facts to that section of the zoning ordinance to come up with your conclusion that either those facts comply with the ordinance or they don't.
Okay, so I guess to follow up with that then, if it comes around to me and the lack of timing, the amount of time we're going to do, based on what I have, this is why I did, made my decision, right here. I'm not going to drill down on each one.
Not sure I understand what you're asking.
I'm simplifying it. I don't want to have 18 line items to create my decision. I want to make my decision on one little chapter, zoning ordinance, and move on.
if the facts of the case and the question you're being asked to address allow for that, then that's fine.
Okay,
But sometimes you need to be a little more detailed.
okay. Okay,
And so it's hard to say, with a hard and fast rule, I can get there in one step.
okay,
Sometimes you can't. Sometimes you need 2 or 3 steps.
okay.
And like I said, each case is different. So once a case gets decided by the ZBA, again, this concept of aggrieved party comes up because an aggrieved party has the right to appeal that decision to the circuit court. And the Zoning Enabling Act says that the time period for an appeal must be stated in the zoning ordinance. I think your zoning ordinance has a couple of different time periods that could be triggered. I thought I highlighted them. No, that is in the statute. It's not in your ordinance. So in order to be considered timely, an appeal being filed with the circuit court from a ZBA decision has to be filed either 30 days after the Zoning Board of Appeals issues its decision in writing, signed by the chairperson or another member of the Zoning Board of Appeals, or if you don't do that, and you don't have to issue written opinions that way, 21 days after the Zoning Board of Appeals approved the minutes of its decision. So if you decide something tonight, you don't issue a written ruling on it. Next month, you approve the minutes of this meeting where the decision was made. It's 21 days after that is their appeal period. And so there's a time limit on when appeals can be filed, and the obvious reason is because the longer things sit, the more difficult it is to recreate what happened. People's memories fade, so on and so forth. So we've got a time limit on an appeal to the circuit court. Again, this concept of an aggrieved party comes up. Only aggrieved parties can file appeals to the circuit court. So again, we get back into this Saugatuck Dunes case. And then the court is acting as an appellate court in this instance. Most of the time when you go to a circuit court, it's the trial court. It's the court of first instance, and it's going to take a look just like you do. They're going to look at all the facts and they're going to apply the law to it, and they're going to come up with a decision. But in the context of an appeal, the role of the circuit court judge is different. And what's nice about the decision and order in the Ansell case, which I believe you received a copy of, is that the judge walks through what the role of the circuit court is in that opinion, starting at page 3, about in the middle of the page. And he talks about the level of evidence.
It was at the end of the packet. It's like 6 or 8 pages.
Oh, in this packet, okay. Gotcha, thank you.
So basically, the circuit court is sitting there asking itself, is the decision that the ZBA made authorized by law? And is it supported by competent, material, and substantial evidence on the record? So supported by law is just simply, did you follow proper procedure in terms of the hearing that you gave the applicant? And is the decision that you reached authorized by the Zoning Enabling Act or your zoning ordinance? I don't think I've ever had an appeal from a ZBA shot down because the court ruled it wasn't proper under the law. What really is the issue in these appeals is was the decision that the ZBA made supported by competent material and substantial evidence on the whole record? And that's why the circuit court being able to read in your minutes what you did and why you did it is important, because that's where the court's looking at what is the competent material, substantial evidence on the whole record. The court states substantial evidence is that which a reasonable mind would accept as adequate to support a decision, being more than a mere scintilla, but less than a preponderance of the evidence. So, you're eyeballing it. Does the evidence support the decision that you make? And circuit courts are not authorized to impose the judge's own decision on the ZBA. So in other words, so long as what the ZBA did is supported by the evidence in the record, even if the judge would have come to a different result, had the judge been sitting on the ZBA, they can't reverse you. They can't impose their own will on the ZBA. That's all part of local rule. You guys get to make your own decisions, and so long as you're supporting them with this competent, substantial, and material evidence on the record, you get to make the decisions you make, even if somebody else would make a different decision. The court states a court will not set aside findings merely because alternative findings also could have been supported by substantial evidence on the record. And then on page 4, the first full paragraph, the court gets into the real meat of Ansell's complaint, where it states, appellant argues that the ZBA failed to explain how the special conditions or circumstances necessitating the variance were a result from the actions of the applicant. And in the next paragraph, the court says that the ZBA concluded that the original decision where to place the residence and septic field was attributable to appellant's predecessor in title. And then he goes back to the zoning ordinance that says that doesn't create special circumstances, therefore the decision of the ZBA was appropriate. So you get a little window into the thought process of the judge and how the judge is applying your findings of fact to the standards that you have to apply, and finding that, yes, there were facts stated in there that substantiated the ZBA's decision with respect to that particular standard.
So can I ask a question
Sure.
here? So in our zoning ordinance, the actions of the applicant, I think in certain court decisions have included, they've agreed that that includes a predecessor in title. The problem is if you don't say it, doesn't mean that that becomes an issue. Does that need to be in the ordinance?
I think it is in your ordinance, isn't it?
Well, I think it's coming out. I don't think the revised version you did, it's in there. And I kind of pushed for it to be in there because people don't understand that the result of the applicant includes anything that's been done on the property. You know, if you've built a structure, somebody else buys it and doesn't like where it's situated, so therefore they can get a variance because it doesn't leave room for them to do what they want. So to me, that does include, I mean, the applicant does include predecessor in title. The problem is that not everybody agrees with that or understands that includes predecessor in title.
Yeah, it gets to the issue of a self-inflicted wound and whether or not that has to be by the applicant themselves or their predecessors. And I think it has historically been the case, as you state, that it really needs to be something that was not created by the property owner at the time that the issue was created, not at the time that the ZBA is considering it. So what you're talking about is And I'm agreeing with you in a very inarticulate way.
Okay, I'm just trying to understand.
I would leave it in the zoning ordinance. I don't understand why you would take that out.
Well, I just
you
think it helps
invite-
clarify whether applicant means, includes predecessor and
Sure.
title or not. I believe it should. I believe there's been some Michigan cases that have actually used that in their decision. And so, and I just think if you don't, then every time the property sells, somebody can say, well, they did it.
Yeah, and then you got to educate them and go through that whole process rather than just being able to look at
Whereas
the
if
ordinance.
this is in there, then it's
Yeah, I
there.
would agree with you
You
there.
don't have to
I agree.
argue with them about it.
Laura, are you saying that it's not in there anymore?
I think they were talking about taking it out.
Who's
I-
they?
I'd have to look at what the amendment was.
I believe it's in this one, but in the,
Right.
when we rewrote it, you just took the, basically the words from the, is it the MTA or MAP?
Yeah,
Whatever. And that predecessor and title got dropped.
it's not in that one.
Yeah,
Yeah. Well, we can look at it. I mean, it's at the county right now. So when it goes to the board, they can add it in there.
So Todd, are we saying that when we cross our Ts and dot our Is, the circuit court is just looking at that point?
Well,
Or is it going to be perhaps, if we're saying the helicopter is not a common mode of transportation, so now are they going to look at that? Because that's not really a concrete thing, even though it's not usual in this area. That's what I don't understand. When is it going to be turned against our ruling?
well, to use that as an example, I remember from that hearing that we talked about, okay, are there any other helicopter pads in the township? Are there any other people that use helicopters to access their residential property? And we got to the point where there was no evidence presented that those activities were being used. And so the ZBA, I'm going to paraphrase, but reached the conclusion that helicopters were not a general mode of transportation to and from residential homes in Torch Lake Township. And so that was sufficient basis to reach that conclusion. What you don't want to do is just make a bald-faced allegation that really doesn't pass the smell test without any evidence to back it up, whether it's information from the zoning administrator about how many times these types of activities have been permitted on properties, again, each case is different. And so it's hard to speak in generalities, but the more findings of fact you have, the more specific they are, of course, the better
Better it is.
that they are.
I mean, I think in that example, the process that the ZBA went through where they go, okay, there are no other helicopter pads. I don't know exactly what the finding is, but there are no other helicopter pads. Therefore, it's not a common mode of transportation versus just saying it's not a common mode of
Right.
transportation. The judge may still agree with that, but I think that your attorney might be like, I wish there was more discussion about why you feel it's not a common mode of transportation. I mean, I don't think you can say too much in a finding like
No,
that
I
to
don't think so
explain
either.
your decision. Can you just briefly touch on what the record is or what information the judge is reviewing, or if additional information can be given to the judge, that process?
So when, again, highlighting the difference between a circuit court as a trial court and a circuit court as an appellate court. Appellate courts simply look at what happened down below. And down below here is you folks, the ZBA. And so when an appeal gets filed to the circuit court, we have to file what is called the record on appeal. The record on appeal includes anything that you considered in making your decision. So it includes the zoning ordinance. It includes the packet the meeting packet that you get from Sarah. It includes community letters that come in, correspondence that gets included into the minutes of the meeting. It includes the minutes of the meeting. It includes the minutes of the next meeting, which approve the minutes of the original meeting. And so anything that you had to look at and to base your decision on is what the circuit court gets. And one of the rules of appeals is you can't expand the record on appeal. So in other words, we can't say after the fact, gee, I wish we had a little more information on that particular issue, and slide something in that wasn't part of the decision-making process originally. And a lot of times appellants try and do that. They'll try and add something that was never presented to the ZBA. And the court's going to say, nah, not coming in. Not going to look at it, not going to read it.
Does the judge ever look at the videos? Or does the judge ever look at any of the live streams or not?
Generally not. The minutes are the official record of the ZBA.
Okay.
And so unless somebody is presenting a video as part of their presentation, that's not going to be submitted to the court. So if you tape record your meetings or video your meetings, that doesn't get submitted to the court. What gets submitted are the minutes. So the options then that the court has when they're looking at an appeal is they can either uphold the appeal, in other words, uphold the ruling of the ZBA like the court did in Ansel. The court could say, well, sorry, nice try, but you got it wrong. You didn't support your decision with substantial competent material evidence on the record, and therefore I'm reversing the decision of the ZBA. Zoning administrator has to issue the land use permit or whatever the case might be. Or, as I said earlier, the court could say, I can't tell what you did. I don't have enough information in the minutes or the record before me to understand what you did or why you did it. So I'm going to send it back to you and have you fill in the gaps for me. And hopefully they tell you what you need to do. But our goal is to avoid putting the court in that situation where it has to send something back to us.
Time, would there be a time limit on that? If it was sent back to the,
A lot of times the court will say, you need to consider this at your next regular meeting. The issue that comes up, of course, is if something comes back that is part of a public process, like a hearing, notices need to be sent out. The meeting needs to be scheduled so far out in advance. So usually the court will not give you a hard and fast deadline, but tell you got to do it as soon as practical. So in other words, like 300-foot notices might need to go out. Again, I don't know. There could be some things that require some timing components that dictate when you can actually rehear that. But it would have to be almost a do-over. So starting from
So
scratch
you
again.
could bring more evidence into the next, when you hear it again, right?
Possibly. It all depends on what the court is asking you to do. If the court is saying there aren't sufficient findings of fact here, then yes, it could be opening up the evidence again and gathering more information to substantiate what was done or the new conclusion reached. One other thing that I did want to mention, there is a provision in the Zoning Enabling Act that has kind of become known as the same matter rule. And this only applies to the Planning Commission representative or the board representative on the ZBA. And what it says is a member of the Zoning Board of Appeals who is also a member of the Zoning Commission, the Planning Commission, or the legislative body shall not participate in a public hearing or on a vote on the same matter that the member voted on as a member of the Zoning Commission, Planning Commission, or legislative body. Basically, what it is saying is that if you serve on the Planning Commission or the Township Board, and a matter comes before the ZBA that you already voted on the Planning Commission or the Township Board, you can't vote on it again. You've got to recuse yourself. So it might only apply to 2 people on the board, but it's an important rule to know to make sure you don't inadvertently get caught in an invalid vote.
And I don't recall off the top of my head, but I don't think our ordinance allows for appeals of like special use permits and PUDs to the ZBA. I think they're appealed to circuit court.
They're pretty limited circumstances when that could come up, but it's just a rule that you need to have in the back of your mind.
What about if somebody voted on a site plan or a special use permit, but that special use permit needed a variance?
I would err on the side of calling that the same matter and not voting on it at the ZBA level. Matter of fact, recuse yourself from the meeting and let the alternate sit in and handle it.
Or the other way around, if they came for the variance first and then I got to the planning commission?
Yep, well, I think that's probably good form. I don't know that there's a corollary rule with the planning commission, is there? Do you
I don't
know
remember.
off the top of your head?
I don't think so, but
I just think it makes sense if you've already staked out a position because of a previous vote, that you declare a conflict and not vote on it again. Too many questions arise if you do. So that's pretty much what I have. Are there any other questions, comments, concerns? Rita wants to talk about the Bob Spencer
I do.
minutes.
This has been bothering me for 3 years. So on page 3 or 4 of the handout that I gave you, at the bottom of page 3, it says, Barr made a motion, uncovered rocks, boulders, or any kind of riprap placed for shoreline stabilization or landscape without the use of rebar, cement, or any other substance that secures rock from moving is not a structure in accordance with TLT zoning ordinance chapter 23. So when this went before the 13th Circuit Court judge in December, and it went before Judge Thomas Power, and it had the case number 2020-9225AA. The judge denied Mr. Spencer because he had no standing. But the judge went on to mock the ZBA's definition. In fact, he said, only in George Lake Township are the Egyptian pyramids in Machu Picchu not a structure. So I think it behooves us to go back and relook at that definition.
There
So how-
is,
So how do we do something like that? I mean,
change the ordinance.
we were being ridiculed by a circuit court judge.
The only way you can do that is to change the ordinance. The ZBA does not have the inherent power to rehear a matter.
The ordinance, if you look at the definitions in the ordinance, it does not define that. It's only in this interpretation. So if you look at the definition, it says nothing about rebar or concrete. This says nothing about rebar or concrete. It's only in this interpretation, which Dave Barr, ZBA, was ridiculed for. So how would we need to rectify that situation? So
Well, from a purely legal standpoint, you could do it two ways. One, you could have an amendment to the ordinance that addresses that issue, handling the definition of a structure in the ordinance in such a way that it negates this ruling by the ZBA. The other way you could do it is you could have a different case come before you wherein you interpret structure differently, which would then become controlling. Courts change their mind all the time. We just had it happen in the Supreme Court. There was a long-standing doctrine called the open and obvious doctrine, which said if somebody comes onto your property and they injure themselves on something that is open and obvious, in other words, had they been paying attention, they would have seen it and they would have known that they needed to protect themselves, that they can't sue you for their injuries arising out of that. Supreme Court, that's been that way for 25 years. Supreme Court just chucked that out the window. Said, no, you property owners, you have a duty to protect for even open and obvious dangers. So things change, opinions change. This ZBA can change it. You just can't change it in that exact same case because you can't go back and rehear it.
No, you can't go back and rehear it, but can you ask somebody, can we, as a ZBA, discuss the interpretation of what a structure is and, you know, make the Egyptian pyramids actually a structure?
I don't believe that you have the inherent power to go back and revisit ZBA cases and interpretations that you don't agree with. You do have the power to do that if it comes up in the context of a request for an interpretation that gets presented to you.
So, but the planning commission could take up that issue and decide they want to amend definitions in the
Yes.
ordinance, and they could make a change to the ordinance that would go to the board, right?
Yes.
Follow that.
I mean, the obvious downside of that, and I understand that this is probably a bad decision, but you don't want ZBA interpretations changing every time there's a different makeup of the ZBA. There's got to be continuity in the law being the zoning ordinance, so that people know what they can and can't do, or that Sarah knows what she should and shouldn't do in certain circumstances.
No, I understand, and I'm not questioning that, and it's not me, it's the circuit court judge that made fun of the interpretation. I mean,
Well, have you met Tom Power?
no, I haven't, but he was still a circuit court judge
He
that
was,
said,
yep.
that said.
But
you
it's
know.
not beyond him to make fun of people. And I'm not saying this was right or wrong, but
And I think this is a good point to say that this is one of those items. Both the ZBA and the Planning Commission have reports from each of the other boards, or your ZBA rep at the Planning Commission should have said, oh yeah, and we heard a case about how, you know, an interpretation about a structure, and then that would be the opportunity for the Planning Commission to say, maybe we need to look at that definition, or do we agree with that interpretation? To prompt that to start, because the Planning Commission can amend it, you know, on their own. Somebody can propose an amendment through application to the zoning ordinance. The definition in the draft zoning ordinance that they're working on is different than, you know, this definition. So I think the draft zoning ordinance solves the problem, and I'll double check that too, definition in that. You know, that'll make this interpretation essentially void. Although we do still have to deal with it until that process works its way through. So.
So I have copies of the statutes that I've talked about tonight that I'm going to leave here. I've also got a copy of the Supreme Court case that talks about aggrieved parties. I will leave here. And you got copies of the ICL materials. ICL is the Institute of Continuing Legal Education. And it's really our, as lawyers, one of the first places we look when we've got questions about things. They're very, very good, very thorough. And so the text that I gave you was their discussion of zoning boards of appeals, and a lot of good information in there. The MSU publication was about practical difficulties and dimensional variances. In case you didn't notice, the other oftentimes requested item for a ZBA, at least prior to 2006, was also a use variance. In other words, I live in an R1 district, but I want to have dairy cattle. And so I want you to give me a use variance to allow me to have dairy cattle in my R1 district. I'm going to drain the pool, and that's going to be my sewage pit. And here we go. The legislature in 2006, when they passed the new Zoning Enabling Act, essentially eliminated the rights of ZBAs to grant use variances. And the reason is because the ZBA is not the legislative body. You're not the elected body. That's the board. And the township board is the only entity that can actually pass an ordinance that says this is what you can do on your property. And so a lot of people felt that the ZBA was usurping the responsibility of the township board and doing things like allowing people to have dairy cattle in the R1 zoning district when they shouldn't. And so I don't even think your ordinance says anything about use variances. So that's
Is that something though that the planning commission is looking at, is the different like zonings and stuff? Because I know there was some question at one of our meetings about whether it was R1 or forest reserve or something like that. Is the planning commission looking at the different zoning areas?
In the rewrite, they're looking at the zoning map, but because the master plan hasn't been updated yet, they're not moving districts, adding districts, things like that.
Okay.
The master plan is usually where that gets
That comes from,
initiated.
okay.
You'll redo your master plan, and all of a sudden, gee, this doesn't make sense to have a forest preserve anymore. It needs to be something else.
Right.
And that's,
And when does the master plan get?
When we get done with the zoning ordinance.
Okay.
The zoning ordinance you've used it. It's difficult to read at times. There's conflicting regulations. There were updates that should have been done to comply with case law and changing in laws that just haven't been done. So the intent of that was to kind of clean it up in one big rewrite and then go to the master plan, go through that process, and then come back to the zoning ordinance and actually maybe change policy in a broader way than what the update is doing. That's the intent. There are, not to say that there's not some changes in the update.
Right.
There are, but we're trying to, follow what our current master plan has, which is older too, and needs to be updated and looked at for that. But so we will get to that.
Okay, and then not to like poke the bear or anything like that, but like how, and maybe you can address it being on the board, but what's the progress with that? Like, when do you guys think you'll be through it? Like, do you have any time frame or?
I think they'll need another 2 meetings to review the draft zoning ordinance, and hopefully then we can move it on to a public hearing.
Oh, good.
So
Yeah,
I
it
think
sounds
it's
like it.
it got slowed down a little bit over the summer. It's harder to get people together. So we were having some special meetings and then that kind of stalled out. So hopefully now with the fall, we'll be able to pick some of that up. But they just started their first review of that draft in June, I believe.
Yeah,
So
that's going fast. all
Yeah.
things considered. Okay.
yeah, because it was a draft that was reviewed and then they put it on hold for a little while. So there's probably about 6 or 8 months where they weren't going to deal with it. And then they decided, oh, maybe we better deal with it.
Okay.
So it came back
Selfishly,
to
I
it.
was just curious because we'll
Yeah.
make it easier for us.
Yeah,
So,
hopefully, yeah, yep.
okay, thank you.
So to Kristen's point, because you were talking about the zoning being updated, because Todd made a reference that 20-09A should be updated to remove any aggrieved, any person. So, like you said, if it's moving along, how does that get then into the process? I mean, does Laura need to do something? Does Kevin need to do something? I mean, what do we?
Well, I
there's
can-
kind of these things that Todd was talking about that needs to be updated. What do we need to do to get
Right.
all that stuff in there?
Well, I can talk with Todd to see, because I think a lot of the concerns that he has are addressed in the draft. So if the draft gets stalled again, then it may be something the planning commission needs to take up separately. But, you know, the amount of time that it takes to get an amendment through versus this full ordinance, it may be able to be dealt with. So we can have a conversation about if there's some items that need to be addressed because they're, you know, it has potential liability, or if it's just, you really should when you have time. But I can talk with Todd about that to figure out if it's something for the planning commission.
All right, well, thank you very much.
Shall we move on?
Perfect.
Let's see, public comment again. Bob? No comment? Okay. Thanks. Summary of action items before next ZBA meeting,
We don't have a ZBA meeting.
canceled?
Yep.
Okay. In that case, can I have a motion to adjourn this meeting?
So I'll make that motion. I make a motion, we adjourn.
I second it.
Okay. All those in favor?
Aye.
Opposed? And it is 7:48.
Are you gonna make